the Supreme Court just made it much harder for asylum seekers to get their cases heard. The court ruled 6-3 that people waiting at the U.S. border don't have the right to request asylum unless they've already physically crossed into the country. That means border officers can turn people away at the gate without ever processing their claims, even if they're fleeing violence or persecution. The decision changes decades of immigration practice. 9 Robes uses non-partisan, everyday language to focus on the facts of what the Supreme Court is saying. Here, you'll find clear, concise summaries of every Supreme Court opinion, stripped of legalese and clickbait headlines. Each post breaks down the facts, explains the court's reasoning, and highlights the crucial details that often go unnoticed. It's not just about what the court decided. It's about why those decisions matter, to give you a deeper understanding of the cases that define our nation's legal landscape. These summaries are generated by AI. Be careful and consult reputable sources when in doubt. U.S. Customs and Border Protection used what it called metering. Officers stationed at the border would limit how many people could enter for processing each day, leaving thousands stranded in Mexico for months at a time. Some waited in dangerous conditions. Some were raped, beaten, or drowned while waiting. An immigration advocacy group called Otro Lado sued on behalf of asylum seekers, arguing the government was breaking the law by refusing to even listen to their cases. The lower courts agreed, but the Supreme Court reversed that decision, siding with the government. The wording of the law mattered a lot in the decision. Federal immigration law says people can apply for asylum if they are physically present in the United States or if they arrive in the United States. Those are 2 separate conditions connected by the word or. The asylum seekers argued this language matters. If arrive in just means the same thing as physically present, then why mention it twice? They said arrive in must cover people who show up at the border but haven't been allowed to cross yet. The government disagreed, saying arrive in simply means you have to actually enter the country. Justice Alito, writing for the majority, sided with the government. He used everyday examples to explain his thinking. A football player tackled at the 1-yard line hasn't arrived in the end zone. A letter in the mail carrier's hand hasn't arrived in your mailbox. Same logic applies at the border. The majority also noted that Congress used different language in different parts of the immigration law when it wanted to distinguish between people who actually enter versus those who just try to. That suggested Congress knew the difference and chose its words carefully. The court acknowledged the asylum seekers had a point about the redundancy problem. But it said the overlap made sense because Congress added the arrive in language in 1996 as part of a broader overhaul, and the 2 provisions were simply meant to work together. The 3 dissenting justices, led by Justice Sotomayor, pushed back hard. They pointed out that Congress uses arrives in and arrives at interchangeably elsewhere in the same law. If the majority's reading were correct, those other parts wouldn't make sense. More importantly, they documented the practical effects of metering. Asylum seekers turned away at the border faced rape, violence, and death while waiting in Mexico. Government investigators found the policy was being used even when processing facilities were only 20% full. Justice Jackson added the metering policy had already been canceled nearly 5 years before the court decided this case, so the justices were essentially answering a question that no longer mattered in practice. This decision gives the government broad power to turn people away at the border without hearing their asylum claims. It also signals that at least some justices may be willing to expand presidential power at the border even further. Justice Thomas wrote separately to suggest the president might have inherent constitutional authority to exclude non-citizens that Congress cannot override. That's not the law today, but it's a warning sign about where the court might be heading. For asylum seekers, presenting yourself at a port of entry no longer guarantees you'll get your day in court. The government can simply keep you on the other side of the line. Find us online at 9robes.ai. That's the number, 9robes.ai. Like and share this podcast with friends that like to be informed. Nine Rogues provides AI summaries of U.S. Supreme Court cases. AI makes mistakes. People make mistakes too. We genuinely do our best to provide you with the most accurate summaries, but our best sometimes includes errors.